All persons having business before the Honorable Associate Judges now presiding on the District of Columbia Court of Appeals. All persons, God save this United States and this honorable court. This honorable court is now in session. Please come to order.
Thank you. Good morning. Before I proceed, let me just inquire. We do not have a visual image for the Assistant United States Attorney. Are you on the line?
Yes, Your Honor, I am.
Okay, good. I just wanted to make sure you're there. We have three cases on this morning's calendar. The first one is Damian Graham versus United States, and that's the one we're going to hear first. Counsel?
Good morning, Christina Matheson for Damian Graham. If I could reserve 2 minutes for rebuttal.
Yes, that would be fine.
Thank you. So this is a case about mistaking a threatened person as a threat. The facts, there are quite a few issues to go through here, so there are quite a few facts. The incident began very early morning hours of February 23rd, 2019, when Mr. Graham arrived at Miss Milner's house. Miss Milner lives in a typical brownstone in Southeast Washington, D.C. She has 10 stone steps. They're fairly steep, going up to a small porch before her front door. Miss Milner came outside before Mr. Graham reached the door. She kind of popped her head out and then she stepped out. And so she was between the front door and Mr. Graham as he's coming up the steps. They began to argue. Evidently, Miss Milner had somebody else inside the house that they were arguing about. And then she proceeded to grab Mr. Graham by the collar. She punched him in the face 6 or 7 times. Mr. Graham claimed that he saw stars, and then he slapped Miss Milner to get away.
Can I interrupt you and ask you, while you're recounting these facts, it's one of the things that's interesting about this case is that a lot of the facts come from the defendant's testimony and the defense witness. And I wonder if what is your opinion about how much, in a sufficiency claim, we're usually used to looking at the light most favorable to the verdict. And what is your opinion about how the trial court views the defendant's testimony? I understand that she reaches some conclusions based on it, which makes you think she's crediting some of it. But, a lot of what you're describing is sort of his testimony. Can we accept that as testimony credited by the judge?
Your Honor, when you look at not just his testimony, but also at the video, there's a body-worn camera video, and the part that was admitted, there's some, he's asking the police detective to look at his face. The officer acknowledges that that he sees something on Mr. Graham's face, which supports what Mr. Graham has said in his testimony. So to the degree that the court finds certain aspects, specifically, I know she did not credit his seeing stars. The fact that he has been punched in the face and he has a black eye, the police, the responding officer acknowledged that was indeed the case. And so it's really a question of when you get into what the court was looking at in the facts in making her decision, she put a strong emphasis on Mr. Graham approaching the door. What we are talking about is a very small porch with 10 steep steps behind it. That is shown also in the video.
But she doesn't, I don't recall anything in her findings of fact about stone steps or his fear of falling, what she says is, I find that he was trying to unlawfully enter the house. And I'm wondering, do you agree that there's support for that in the record?
Sorry, I don't mean to, no. The government did not present evidence of there being an attempt at a forcible entry. In fact, the evidence is even from the officers that Miss Graham is out. I'm sorry, Miss Milner is out on the porch, and that the confrontation happens before he reaches the door. So he has not even knocked on the door
Right, but-
to sort of announce his presence.
If the officers didn't see what happened, right? And we do have Mr. Graham's testimony. And I don't know if this is what the trial judge was seizing on, but Mr. Graham says she was grabbing me on my shirt, trying to push me away from her door because I was getting closer and closer back to the door. Is that the gist of what we're working with here? And do you take that to mean he was saying I was getting closer to the door? It's a little confusing because it says closer back to the door.
I understand what you're asking. Yes, I think that phrase, that's what the court is relying on and what she really kind of emphasizes. But that in and of itself, getting closer to it's a small porch, and he's talking about in the same testimony, he's also talking about his fear of falling down those steps and that his back is to the steps. And so he is actually trying to just not be on the steps and stay on the porch rather than getting into the door. But there's no.
But that sounds like you have a different take on it than the trial judge did, which isn't really a basis for reversal in this court, is it? Do you think it's like constitutionally insufficient, or do you just think there are better? There's more than one way to look at it, and the trial judge's way wasn't really the best way, because I'm not sure that's a good argument.
So I do think it's actually insufficient. It's very briefly talked about that he is approaching the door. The circumstances of his approaching the door is not. It's not like Miss Milner has described him coming in and with his arms raised or something. There's no description of how he is approaching, other than they are verbally arguing at that point. And then it's his own, description of, it's a small porch.
So do you think, there needs to be something like, he's like, let me in, I'm going to get that guy, or pushing her past and touching the door, or do you need that kind of evidence?
So I think, where the court has, the lower court has said that this is a forcible entry or an attempted forcible entry. Yes, I think, we need to look at what the legal standard is for forcible entry, and that was not talked about, and that was not disproved by the government. And where Mr. Graham has asserted a claim of self-defense, it is up to the government to disprove the circumstances that essentially that he did not have a belief of imminent bodily harm, which he truly did, and he described that for the court. And he also described that for the officers, the responding officers, who, when they arrived, found him across the street. So nowhere close to Miss Milner. So once he was able to escape, he did truly try to de-escalate and then waited for the police. So I think your original question was, looking at the sufficiency of the evidence regarding approaching the door. And I think there is a lack of evidence here, and we really need to look at what the legal standard is for forcible entry, which was not put on in this case. That was not discussed, but that is the crux of the trial court's decision to deny Mr. Graham's self-defense claim. Essentially, the trial court has found that going to somebody's stoop is an aggressive act. Showing up on somebody's stoop is an aggressive act. And therefore, it just really kind of turns this case on its head. And, you know, the reality is that he was walking up the steps, was intending to knock on the door, didn't even reach the door, and he's being grabbed and punched. And then he slaps Miss Milner, and he does his best to escape, and then does in fact escape and goes across the street. So there are some additional issues in that. Again, so the government has the burden of disproving whether Mr. Graham had a belief of imminent bodily harm. In addition, the government needs to prove that he did not use excessive force. And again, that is not something that the trial court even gets to. And in this case, it's very clear that he used less force than what was being perpetrated upon him. So he actually de-escalated the violence. And then, like I said, he retreated across the street to wait for police arrival. Once the police came, he was pretty much told immediately that he was detained. He was not necessarily under arrest, but he was detained. He was asked what's going on, and he admitted that he had slapped Miss Milner. He was not given any kind of Miranda warnings at that point. Oh, I'm sorry, Judge Glickman, I think you're muted.
Thank you. You're quite right. Ms. Matheson, let me ask you, is it your position that there is simply insufficient evidence to permit the judge to find, beyond a reasonable doubt, that the government has disproven self-defense, and that therefore he should be reversed and cannot be retried again, or are you arguing for a retrial?
Yes, that is my position, that it needs to be reversed.
For insufficiency of the evidence.
Correct.
So in a nutshell, your argument is that there was no evidence to support the judge's essential finding that he was the first aggressor, and no evidence by which the government managed to disprove the claim of self-defense.
Correct.
Let us hear from the government now, and we'll give you a few minutes in rebuttal.
Thank you.
Thank you. May it please the court, on behalf of the United States. In this case, there was sufficient evidence to convict appellant of assault. Of assault because the record taken the light most favorable to the government established that appellant was trying by force to enter Ms. Milner's home when she'd made it clear to him that she did not want her. And we know this from appellant's own testimony, from appellant's actions on the 911 call, and from Milner's statements on the 911 call, which I would note was not even referred to in my opponent's argument. First of all, if we take...
Pinpoint to us what you're talking about. Maybe I'm interrupting you and you're about to do that.
Yes, Your Honor. First, taking appellant's own testimony, which, as all evidence in a sufficiency claim is viewed in the light most favorable to the government, appellant made it clear in his own testimony that his purpose was to get into Ms. Milner's home, did not want him there. On page 79. On page 79.
I'm sorry, we're having trouble hearing you.
On page 79 of the transcript, appellant makes reference to his intention to get him out of her house, meaning her mail company, about whom he admitted he was upset was inside the house. He also, again, refers to the idea of bring the other out with respect to what he was there to do and what she didn't want him to do and why she was blocking him from coming in. And what his testimony showed is that when he arrived at 2:30 a.m. at her home, she came out onto the porch, made it clear that she had company and that he was not welcome, closed the door behind her in as a nonverbal cue that he was not welcome there. And then his own testimony suggests, in the light most favorable to the government, that he tried to push his way in. And I refer to the same quotation that the trial court relied on and Judge Beckwith mentioned earlier, that he was pushing his way, he was getting closer and closer, pushing back to the door.
Can I just take you back, Ms. Ament, to on page 79? Are you talking about the his testimony that the question is, and then what happened while you're arguing? And he says, while I'm arguing, she's trying to get me to calm down, not be so loud. I guess she didn't want me to bring him out the house. Is that what you're talking about? And isn't that just his speculation about what she's thinking? Is that actually evidence of what he's doing?
Your Honor, in the light most favorable to the government, yes, because he is the one who raises the idea that what anyone would interpret him doing was to bring him out of the house.
I don't know that anyone would, I'm sorry, but in context, the sentence is calm down, not be so loud. It makes it sound like she doesn't want him to wake other people up or disturb people inside the house. And it's, I guess she didn't want me to bring him. I mean, yeah, we look at the evidence in the light most favorable to the government, but at some point, ambiguous evidence is ambiguous evidence, and there's no follow-up question of what do you mean she didn't want me to bring him out of the house after the comments about being loud.
Well, Your Honor, he repeats that again on page 80 and doesn't mention anything about loudness being what would happen. And
well, she does. I mean, he says, when you said she started pushing you, and this is on page 80, what do you mean by that? Like, I guess she was mad that I was making a lot of noise. She didn't want me to bring the other out. So that the noise and the sound is linked on both occasions to bringing someone out of the house, which reads to me that she doesn't want him to disturb anyone else.
Your Honor, we would submit that the trial court found to the contrary, and the trial court was
Did the trial court reference this testimony at all?
No, Your Honor, but the trial court did find that he was trying to force his way in, and this only corroborates that, as does the testimony that her response to him was because he was moving closer and closer back to the door, suggesting he'd been approaching the door when it was clear that she did not want him there. And his obligation when she asked him to leave wasn't to push closer and closer to the door. It was to actually leave. In addition to those statements that he makes, he also, if we look at everything in its entirety, at the evidence in its entirety, he is extremely angry here. And there can be no question about that. He admits to it, number one. Number two, he admits that he was being loud. And number three, when you listen to the 911 call, it suggests that he is remaining on her porch, contrary to the argument we just heard and his own testimony that he ran away as soon as she went inside. No, you can hear on the 911 call his shouting, including at 40 seconds in, "I'm going to knock the shit out of you," suggesting again that he wants forcibly to encounter her and enter the house. She tells him to get off her porch, suggesting that he is still refusing to leave when he has had it made clear to him through words and actions that he is not welcome there.
That
To the
part of the tape that you just quoted, did the government play that part of the tape to the court,
yes,
that I'm gonna knock the shit out of you?
yes, you can hear him shouting that in the
No, I know
background.
you, well, I can go back and listen to the tape, but I thought I thought you said in your brief that only a snippet of the recording was played for the court. And that
I
it
believe-
wasn't at that
I
point.
I believe the snippet was of the body cam footage, Your Honor, not the 911 call, which I believe was played in its entirety.
Oh, I'm sorry, you're talking about the 911 call. I got them confused.
Yes.
I apologize.
Yes, Your Honor, the 911 call where you can hear him yelling to her as she's talking to the 911 operator, I'm going to knock the shit out of you.
Right, and she's
and-
yelling back at him. You
Get
want
off
me
my
to Put
porch.
on my shoes, I'll come out and dance with you. Or something.
That follows that, Your Honor, but she's also told him to get off of her porch, suggesting, number one, that he out and out lied to the trial court when he said that as soon as she closed her door, he ran away and went across the street, in which that argument was repeated this morning. But he's still on her porch when she calls 911. And I think that puts the lie to his testimony, A, that he was trying to defend himself, and B, that he wasn't trying to force his way into the house, or that his motives were only to keep from waking anyone up inside the house.
Does his presence unwanted on the porch constitute some sort of unlawful entry? Is that, I mean, we're looking at a court's ruling that he is the first aggressor because he's trying to force entry into the house. And it seems like the evidence of him trying to force entry into the house is pretty thin, but now you're talking about his presence on the porch being unwanted. Is that a legitimate basis for saying he's the first aggressor?
Yes, Your Honor, we would submit that it is. But more than that, his presence on the porch suggests that he is not going to leave as she requested unless he's actually allowed admittance. I mean, this whole situation, and he admits that he wanted to go inside there. He said, I went over there to see her. And he mentions bringing the other person out. He mentions not being happy that she didn't want him there. I mean, it's clear that he is not going over there simply to stand on the porch.
Can I ask
that
a
he-
Going
question?
over there,
Ms.
I'm sorry, he's going over there because he thinks that they're gonna have, they're gonna have a little get together. And it's only when he gets there that he realizes that someone else is already there. So I'm not sure how much you can rely on the fact that before he gets there, he would like to be in the house. Yes, he would like to be admitted so that he can have a romantic encounter with her, but then he arrives and circumstances are not what he anticipated. Right?
Yes, the circumstances were not what he anticipated, but he clearly
So
wants
my question
more.
is, how much can we rely on his desire to enter the house before he arrives? It seems like not at all.
Well, Your Honor, my only point in mentioning that was that the record refutes any idea that that it was fine if that he only went there to stand on the porch and yell. He went over there expecting that he would be admitted. And when he is told he will not be admitted, he continues to demand that the complainant take action that he wants her to take. And he moves toward the door in pursuance of that. He does not leave as she asks him to do, and he remains there yelling at her, demanding a confrontation once she's closed the door. And
What
he
is
remains.
what is the evidence that he's trying to get her to do what he wants, or that he's demanding a confrontation? I'm not doubting it, but what are you pointing to?
Well, saying that he's going to knock the shit out of her suggests that he wants her to come back and confront him. And once that door is open and he's been pushing closer and closer toward it, the trial court could find, taking in the evidence in the light most favorable to the government, that what he wants is to enter the house. And he wants to enter the house against her wishes, and she has tried through telling him, through closing the door, and through pushing him that she doesn't want him there. And he's insisting upon remaining and insisting upon demanding action of her.
Can I
And the trial
ask you
court-
to, I'm sorry, Ms. Ament, can I ask you to clarify one thing? When you said it's clear from the 911 call that he's still on the porch, I think you mean she said that, right? But don't we hear his voice kind of far off? Or I didn't have great audio when I listened to this, but can you tell me what you're taking that from? What's the basis of your statement in that regard?
She tells him to get off her porch while she's speaking to the 911 operator.
Okay. And do you agree that there's some, like, when he's talking to her, he sounds far away at some point?
Your Honor, it seems as though he ends up at the end of the call further away than he was at the beginning, but we would submit that his testimony that he was across the street when she called the police, which was again relied upon in my opponent's argument, is just refuted, put the lie to by the 911 call, because I don't think that sounds like it's coming from across the street, and to the point that I don't think that it sounds like he's coming from across the street, and she's saying, get off my porch when he's across the street. And so the trial court could rely on that to suggest that his intention was to remain, there and try to force his way into the house if given the chance to do it. And we would submit that because that he came there, he was told he was unwanted, he remained on her porch, yelling at her, and used and pushed his way closer to the door, that the trial court could find that this was not a case of self-defense, because any action that Ms. Milner took was reasonable defense of property, and that he was the first aggressor or had provoked the conflict on himself. That finding is supported by the trial court's credibility findings and by all of the evidence in the record, including the 911 call and appellant's own statements and appellant's own actions on the on the body cam footage, in which his angry attitude and his admission that he smacked the shit out of her were also included. And so we would submit that the first aggressor finding was supported by the record, and the evidence was sufficient to take this case out of the realm of self-defense. Even if that isn't the case, there is simply no evidence in the record that was credited, because the trial court discredits appellant's argument that he believed he was in fear of his life or in danger, that he didn't actually or reasonably believe that he was in imminent danger of harm. And so even if first aggressor finding is refuted, which we would submit it should not be, he did not actually act in furtherance of defending himself. He's constantly here acting in furtherance of forcing his way into this house, confronting the complaining witness out of anger about her having other male company. And that self-defense, the trial court discredited his argument that these slaps were in self-defense. And so for those reasons, we would submit that the evidence was sufficient. If there are no further questions on self-defense, we would also submit that, contrary to appellant's argument earlier, there was no custodial interrogation here requiring Miranda warnings. Counsel made reference to the officer's question of what's going on, but appellant was not in custody when that question was asked. So that question does not constitute custodial interrogation, and his remaining statements to officers were spontaneous or part of his argument with Ms. Milner, not in response to any interrogation, even assuming that after being told he was not and handcuffed, he was in custody for Miranda purposes. And those statements in any event, even if there was a Miranda violation, even if there was non-existent custody and non-existent interrogation, were harmless error, because every single statement that he made to the police that were played in that body worn camera footage, he repeated at trial, and adopted at trial. And he never suggested that he wasn't volunteering them to the officers. And if there are no further questions, then we would submit that evidence was sufficient, that there was no confrontation clause or Miranda violation, and we would ask that the judgment of the Superior Court be affirmed. If there are further questions.
Ms. Ament, I just wanted to ask you one thing. Do you think that at trial, the counsel for the government argued the first aggressor theory to the judge?
Yes, Your Honor, I believe, because I believe that they were mentioning her trying to force his way into her house, and the fact that she was trying to defend.
I don't think counsel put it that way exactly. I think the counsel mentioned in closing that the complainant, quote, attempted to push Graham away because she did not want him to enter the house. But aside from that statement, I'm not sure the government really argued this point, and I'm wondering what significance we should attach to that. It's a very funny case because the complainant did not testify.
Your Honor, to be honest, I don't think that there's a lot of significance to be made of that. First of all, because the government counsel did mention this, and secondly, because this was a case in which appellant put self-defense in play, regardless of what the government argued, the trial court was obliged to apply the self-defense law as recounted in the jury instructions. And therefore, the trial court was required to decide, number one, whether this was a case where self-defense was involved, i.e. whether there was a first aggressor, whether appellant was the first aggressor who is now trying to claim self-defense, or whether he had provoked the conflict on himself. That's clear from the jury instructions.
In terms of who was the first aggressor, is there any evidence contradicting the testimony that the first person to actually use physical force was Ms. Milner?
Your Honor, we would submit that no, I don't believe that that there's any actual evidence that where appellant admits he was the first one to use force, but the way it says getting closer and closer back to the door could suggest that that he was pushing his way into her personal space, which could be taken as physical force. It seems like his entire contention was that the first thing she did was trying to push him away. And so that is somewhat ambiguous.
You see, I think he acknowledged that he was there to come see her and that he got into an argument with her and they were yelling at each other and so forth. But I don't think, it's not clear to me that he acknowledged or that the judge could really find from all this hullabaloo that he was attempting to forcibly enter the house against her will. Now, you can fairly say that he was attempting to stay on the porch for a while against her will. I suppose one could make that inference. But I don't know if even if that is true, it bothers me to think that the fact that they're having an argument on their porch, and a heated one, justifies her in starting to slap and punch him. And there's certainly evidence that corroborates the fact that he was punched in some way, he was injured. The police officer noticed it.
Well, Your Honor,
That's what sort of I feel like I have to weigh in this case, how strong the evidence really is to support an inference that he was forcing his way, or trying to force his way in over her objection. And when the prosecutor didn't seem to argue it, there's no testimony directly stating it. And and the judge seems to pull this together from rather cryptic remarks. You've done a good job pointing out that one, I suppose, could think this is what happened, but I wonder if the judge could fairly say, this is what I find happened beyond a reasonable doubt.
Your Honor, we would submit that, that again, viewing this in the light most favorable to the government where it's ambiguous, what the trial court found was that she was not required on her own property to back up essentially and let him in. So if he's moving closer and closer to getting back to the door, we would submit that that the court was
that testimony, you see, the thing is that statement that he's moving closer and closer to get to the door is one that, I'm just trying to decide whether we really can tease that out of the evidence. That's, I suppose, the key question, you would say.
Well, Your Honor, I think what the question the trial court asked is, and what this court needs to ask is, under the law of defense of property, was Ms. Milner obliged, as he came closer and closer, getting back to a position he'd had at the door before, because that's fair from that statement, was she obliged to simply stand there and let him press back and enter her home? Because that was the only option. She was standing with her back to her door that she had shut to try to keep him out. Probably hadn't locked it.
I just don't think the evidence shows that she's standing with the back to the door. I mean, they're clearly moving around on the porch. She's grabbing me and pushing me. I'm yelling. This is at the bottom of 80. And then, yes, she's grabbing me, trying to push me away from her door, but it's not clear where she is. It's not really clear where he is. And I take your point that this theory could have been argued and the government could have asked some follow-up questions right there at the top of 81. Where was she relative to the door? Where were you? Were you trying to get into the house? But the government doesn't elicit any of that testimony. So
Well, Your Honor,
theoretically, it seems like this could have been argued, but it wasn't. And that's why the evidence really seems perilously thin.
well, Your Honor, I would submit, in the light most favorable to the government, or even just common sense, if I'm attempting to push somebody away from my door, I'm closer to the door than they are. And therefore, if I'm trying to push him away and he's coming closer and closer, I'm being left with no alternative, either under the court's theory to move to the side and let him in, or I'm being backed into my own door. This is her own property that she's entitled to defend. And so the fact that she would try to push him away as he's coming closer and closer is just simply a defense of property. And his coming closer and closer is a forcible intrusion on her property. And the trial court discredited his idea, that his testimony, that his intention was any other than that. And we would submit that credibility finding, given this situation, was not clearly erroneous. He is essentially admitted in his testimony, bring the other out is not interpretable very much else as you want to stay there, go into the house, find this other person that you didn't want to be in her house to begin with. and do something with them. I don't know what bring the other out else could mean, and certainly in light most favorable to the government, that's what it
Are you,
means.
is that the page 79 thing? that I
79
guess-
and 80.
Okay, because again, I hear you, but that he's talking about, he's speculating about what she might be thinking. I don't know. It's very vague, and it does seem to be. It does seem to be to involve. If you can glean anything from it, it seems to be about noise. Like he's going to come out because he's hearing this noise.
Your Honor, we would submit that, first of all, remember, his testimony is intended to be self-serving. And so the only glean to be put on it is the noise. We would submit is not taking this in the light most favorable to the government. In the light most favorable to the government, bring the other out, spoken by an angry person who several times in this record mentions smacking the shit out of the complaining witness, is that much more angry at the person who's inside and is attempting to use force to provoke some type of a conflict with that person. And the fact that he projects those kinds of thoughts onto the complainant is relevant evidence that that was what he was thinking about. He didn't just make that up out of nothing. And we would submit that the trial court listened to all this evidence, listened to the 911 call, watched the body cam footage, and concluded that this person's intention was not to defend himself, but was to forcibly provoke some type of encounter with Ms. Milner and or her company. And that finding is supported by this record, and the evidence therefore was sufficient to show that appellant provoked this conflict on himself or was the first aggressor here.
Ms. Hammond, thank you.
If there are no further questions, we would ask that the judgment of the Superior Court be affirmed.
Thank you. Ms. Matheson, we'll give you a few minutes. Can you hear me?
Yep, I can hear you.
Let me, if I may, ask you to address this. Mr. Graham testified that Ms. Milner was grabbing him on his shirt, trying to push him away from her door, quote, because he was getting closer and closer back to the door. Now, that seems like an admission on Mr. Graham that against her will, he was trying to get to that door. How do you respond to that?
I think, what he's talking about is she also had a grab on his shirt. So it's not that she was just pushing him. And as I think they're just sort of scuffling, and I think he's describing, again, it's a small porch. It's a normal stoop. So we're talking about, a couple of feet. He has stairs behind him that he is worried about falling down. And so I think he is just truthfully trying to describe for the court the circumstances of just trying to get on the porch for safety, not necessarily on the porch.
Let me press you on that. That is one view of the evidence. It's a view of the evidence I could imagine hearing the government saying in the light most favorable to the defense. But we have to look at the evidence in the light most favorable to sustaining the judge's verdict. Why is it the trial judge could not interpret the evidence pretty much as Ms. Amond has described it, and relying in part, but perhaps heavy part, on Mr. Graham's own admission that he was getting closer and closer back to the door. The back to suggests that he was there. He was at the door at one point in time, had been pushed back and was pushed away from it, and was nonetheless getting back to it. closer and closer. Um, You take my point, I trust.
I do, Your Honor. I think the government, that there are two, it's kind of a two-part answer. One is, as I think all three of you have noted, the prosecution did not make this argument at the trial. This was something that the court pulled from this particular testimony and really ran with. But that there was not evidence put on about forcible entry and this kind of thing. Secondly, the government relies very heavily on some inferences from the 911 call, which are not necessarily there and were not remarked upon by the trial court itself. But what we know, and we don't have to infer, is that when the responding officers arrived, Mr. Graham was in fact across the street. So when you listen to the 911 call, I agree that his voice sounded distant. It did not sound to me that he is in her face yelling, while she's got her back to the door. There's taunting going both ways.
But Ms. Amont's point, I think, was that may have been true toward the end of the call, but at some point, the complaining witness, the complainant, it's not really the witness at trial, but says, "Get off my porch," which seems to pretty strongly indicate he's on the porch.
She does say, "Get off my porch," but then when you hear his response, as I think you had noted earlier, his response, the volume of his voice is very distant. I don't think that is a quality of the audio. I think that he is in fact distant. But again, these are inferences that we have to make from, the sound or the volume of things. Whereas if you look at the facts that we have, you can hear Ms. Milner taunting Mr. Graham, I would say arguably more than what he is giving back. And when the officers arrive, they see that Mr. Graham is in fact across the street and he does have a black eye. Thank you.
By the way, even if we agree with you that much of the 911 call was testimonial and therefore subject to exclusion, do you think that the statement, "Get off my porch," and possibly some other statements in there, but let's just focus on that, was testimonial? I'm thinking that statement comes in regardless, or it comes in. I'm thinking that statement is admissible in evidence regardless of whether other statements in the 911 call are viewed as testimony, and regardless of whether they're hearsay, for that matter. Well, there was no hearsay objection. So
I think when Ms. Milner concludes the call with, "I no longer need the police," she really takes away the testimonial.
you have an argument that some of the statements in the call are testimonial in nature because they're accusatory and whatever. But I'm thinking that perhaps that argument, even if correct, doesn't apply
to that particular
to that particular statement where she's overheard saying to Mr. Graham, "Get off my porch."
I understand what you're saying. I recall from the tape that his very next statement does sound distant, and to me it sounds like perhaps she's saying, "Get off my porch," but maybe he's on the steps. We don't know the circumstances, but it sounds to me that Mr. Graham described the altercation as very quick, very brief, and he did in fact retreat. So "get off my porch," he could have been maybe on the last few steps before the sidewalk or the street, and she's meaning, "Get off my property." entirely. And he does comply. He crosses the street. So it does not describe an ongoing emergency. The fact that if you look at the circumstances surrounding that particular statement, there's just not that exigency that is required for it to be admissible.
Okay.
Thank you.
Counsel, thank you both. The case is now submitted. And both of you may now log off. We'll hear the next case.
Bringing in the next case.
Are all counsel present?
Yes, Judge. Bringing in the next case.
Okay, we'll call the case of John Stephen Mudd versus Occasions Caterers. Okay, counsel, you may proceed. Mr. Greenberg.
Thank you. I'd like to reserve 5 minutes for rebuttal.
Okay.
May it please the court. This appeal involves 3 errors of law made by the trial court. First, the trial court erred by finding as a matter of law that the hiring of new employee Joseph Gwatz into a new position by itself demonstrated clear and manifest intent by appellees to no longer intend to abide by the terms of its employment agreement with appellant, where appellant continued to perform his duties, was never informed that the hiring of this new employee would impact his compensation, and was not provided the required written notice of change in his rate of pay as required by the Wage Theft Act of 2014. Instead, these undisputed material facts demonstrate that the employment agreement continued to be in effect through 2018, when appellant's employer provided him with written notice of termination as required by the document's terms. Therefore, the trial court should have entered judgment in appellant's favor. Second, to the extent that this court finds that the hiring of Mr. Gwatz may have demonstrated some intent by appellees so that Mr. Mudd was not entitled to judgment as a matter of law, it was an error by the trial court to resolve the disputed issue of intent in appellee's favor in the face of contrary conduct by the parties and the Wage Theft Act's required inferences against employers who fail to provide written notice of change in compensation. Third, the trial court abused its discretion by denying appellant's request to amend his complaint to assert a new legal theory of breach of contract based on facts already developed in discovery. Therefore, should this court not instruct the trial court to enter judgment in appellant's favor, the case should be remanded for trial for a jury to resolve whether Mr. Mudd is owed wages under the Wage Payment and Collection Law and whether appellees breached their contract with him. During Mr. Mudd's employment with appellees, he had the expectation based on his written employment contracts that after the end of each calendar year, that he would be paid wages in the form of profit sharing compensation based on 3.33% of Occasion's pre-tax earnings for the year. While these employment contracts had a stated duration of 1 year, the parties continued to abide by their duties and responsibilities in the documents over the course of years without executing new agreements, including paying Mr. Mudd profit sharing compensation. Thus, after the close of the 2017 calendar year, Mr. Mudd expected to be paid his owed profit sharing compensation for the work he had done the prior year. And appellees
May I ask you, is there a genuine factual dispute that once Mr. Gwatz was hired and took over, Mr. Mudd's responsibilities changed in a significant way?
I don't think that there's a genuine dispute of that, Your Honor. I don't think that there's evidence that his responsibilities did significantly change.
And specifically, I guess they significantly changed because he was no longer supervising the accounting department and no longer responsible for overseeing the finances of the organization. Is that a fair summary of the way in which they significantly changed?
Your Honor, no, I don't think that's a fair summary.
What do you think is, in what way do you think it's undisputed that his responsibilities significantly changed?
I think it's undisputed that his responsibilities did not significantly change, Your Honor.
Oh, I'm sorry. I misunderstood what you were saying. I thought the position of both occasions, catering, and the judge is that upon the hiring of the CFO, Mr. Mudd's responsibilities significantly changed, essentially in the two respects I described. Before the hiring, he had supervisory responsibilities and oversight responsibilities in the financial and accounting area. And after the hiring, he did not have those responsibilities. And one thing I wanted to ascertain, because that's the predicate for your adversaries and the judge's determination that there was clear and manifest indication that the company no longer wished to be bound by the contract. So if there's a genuine dispute about that, tell me why that's what it is that gives rise to a genuine dispute about that.
Your Honor, there's a lack of evidence in the record showing that Mr. Mudd's primary responsibilities had in fact changed. Mr. Mudd testified how
Had or had not?
Had not changed. Mr. Mudd testified how his primary responsibilities was things involving payroll, accounts payable, handling financial statements, and reporting general ledger work, and running the accounting department overall. When Mr. Guatz was hired, he was hired to oversee the overall big picture of the company because the company had grown. That overall big picture of the company's finances was never Mr. Mudd's job. Instead, as described by Mr. Michael, the company's president's testimony, when Mr. Guatz was hired, he was essentially taking over Mr. Michael's overall big picture oversight over the accounting department. But Mr. Mudd, as he testified to, continued to run the day-to-day. And
well, what's the testimony or evidence specifically that you point to on this? Because this is something I've been giving some attention to, and I'm not sure what specific testimony you're referring to.
So when Mr. Michael,
or other evidence, if it's not testimony.
So when Mr. Michael proposed, he described how
I mean, Mr. Michael testifies, for example, in response to the question, did his duties change? This is at a deposition.
Yes.
Did his duties change beyond that period, beginning in September 2017? Michael's response, that is to say, Mr. Mudd, was no longer head of the department, so we have a CFO who was managing all the accounting, and so the answer is yes. Prior to that, Mudd had been in charge of the accounting office at the company, finance, and as of September, he was no longer running the office anymore. Mudd was in charge of financial controls up until Guatz came in. Guatz took over the helm of financial management for the company. Follow-up questions. Mudd was not managing accounting staff, correct. Mudd, there are some areas he did retain responsibility for. Nobody's saying he had no work to do. But the principal points that Michaels makes in his deposition are that upon the hiring of Guatz, Mudd's no longer overseeing financial administration and not managing accounting staff. And it's not clear to me that that testimony is in material dispute. And that's what I want to get at.
Thank you, Your Honor. So let me also point out that Mr. Michael, in describing how Mr. Watts would be taking over his role, he described how it was more of that Mr. Quads was taking over his role, sort of the on the big picture oversight of the accounting department, and that's on page 360 of the joint appendix. That in describing the transition, he writes, he says that there was never a conversation about the fact that I, referring to Mr. Michael, was no longer to be running the department, and John was no longer going to be my direct report. So that testimony from Mr. Michael, I believe, describes how Mr. Quads was basically taking over Mr. Michael's responsibility and the overall big picture
Well,
of the company.
although a few pages later, Michael says, I felt like we needed a CFO who had experience managing the size company that we had become with all the complexity. And I felt like the job had sort of become too large for Mud.
Yeah, and that is again, a new position in this company. It was never done before. These sorts of big picture finances were not Mr. Mudd's job description, and not as he described what his duties were. In addition, there is even under what Mr. Mudd's duties were after Mr. Watts came over, there is still a dispute of fact over that.
Well, that's what I want to get at. Show me the point of dispute.
Sure. So on page 208 of the joint appendix, Mr. Mudd describes how after Mr. Quads started, that he would continue to run the accounting, and instead, Mr. Quads would just oversee the overall greater picture of financial matters.
Well, I have that very quote in front of me. And what he says is, he says he was studying after the first, Quads was studying after the first month, and then he would come in and try to take over, yes. But what I was originally told when Joe was hired, I would run accounting and Joe would oversee the greater picture of all the financial matters. So his claim is that's what he was originally told, that he would still run accounting. But the testimony is that changed. And I want to know whether there's, regardless of what he was originally told, there's a dispute about whether it changed.
So, Your Honor, on page 68 of the joint appendix, Mr. Mudd also describes what his duties were for his entire employment with the company. So that would include that period of training. Where the question is, you were in charge for question, is it accurate that you were in charge of payroll for the entirety of your time working on occasions? Yes. And besides payroll, what other functions did you have while working on occasions? So there he describes his duties for his entire employment with the company. And he doesn't describe how that changed in any significant manner.
And that's at Joint Appendix 68. That's the page you were citing.
Yes, Your Honor.
Mr. Greenberg, can I ask you, is there tension between your first and second arguments? And obviously there is one's alternative, but if it's your position that there are these unresolved fact issues and that his duties didn't really change or things like that, does that mean the best result you can get is to a remand for trial, or is there a way that your argument that you should win as a matter of law still, does it survive that?
Your Honor, the standard is that where an employment agreement continues on its stated terms past its stated duration, parties can, if it's shown by clear and manifest words or conduct to no longer intend to abide by those terms, that's when the employment agreement ends. And as a matter of law, I don't think that the hiring Mr. Gawaz by itself, without any other conduct, can show as a matter of law that the parties failed, that the parties intended to discontinue their intention to continue to abide by the terms of the contract through the end of Mr. Mudd's termination, when he was provided the exact notice of intent to end the agreement consistent with those documents' terms. So it's appellant's position that the hiring of Mr. Waz cannot show both clear and manifest intent. But that being said,
Is that really right? Suppose Mr. Waz had been hired and the next day they come in to Mr. Mudd and say, you know, you've been here a long time, we love you. We'd like you now to sweep out the closets, and your hours are going to be 6 p.m. to 2 a.m. in the morning, and this is, we want you to come in and clean the floors and do everything else. Would that have been enough to that sort of complete change in his duties? Would that have been enough to create a clear and manifest intent no longer to, by itself, without saying anything about how your salary is going to change or remain the same or anything of the sort? Would that have been enough, in your view, to be a clear and manifest intent not to be bound by the contract?
yes, Your Honor, I think that if that was so communicated to an employee, instructing the employee, hey, we're going to change your duties, we're going to completely change your position, I do believe that would be enough under those facts. But those facts are here.
Well, so it's a question of how close we've really gotten here, in your view, to those facts. Whether the change, whether the hiring of a CFO who, it is argued, takes on substantial responsibilities that formerly were were those of Mr. Mudd, was enough to convey to Mr. Mudd that the employer no longer wants to be bound by this contract.
Your Honor, again, I believe that there is a dispute about what those duties were. And what
No, I understand that, but you, in answer to Judge Beckwith's question, you were saying that even if it was an even if, that it would not be enough, and that's what I'm sort of focusing on.
Additionally, Your Honor, there is that an additional tension is that under the Wage Theft Act of 2014, there is a required notice that employers are supposed to give when there is a change of compensation. It's essentially augmenting this black letter principle of law that requires affirmative conduct, and that did not occur in this case. So, in addition to the summary judgment standard of resolving inferences in favor of the non-moving party,
I'm sorry, what provision of the Wage Act are you referring to?
I'm referring to DC Code 32-1008, subsection C4, and then relatedly D1.
And do you have those in front of you? Can you say,
Yeah.
Say what exactly they say?
Yes, Your Honor. In full, or
Well, the pertinent part.
the pertinent parts of each employer is required to provide a notice. This notice is required by the subsection shall contain, goes on, the employee's rate of pay and the basis of that rate, including by the hour, shift, day, week, salary piece, commission, and so on. And then subsection D, within 30 days of any change in the information contained in a prior notice, the employer shall furnish each employee an updated notice containing this information again. And
Refresh my memory, was this argument made to Judge Pan?
it was made in the briefings before Judge Pan, yes, Your Honor. And Your Honor, there's a separate subsection D2. If an employer fails to comply with this subsection, the failure shall constitute evidence weighing against the credibility of the employer's testimony regarding the rate of pay promise. So in addition to the inferences that the trial court failed to do regarding just a summary judgment standard, the DC wage law includes a specific further inference required in the employee's favor where there is the failure to provide this notice. And Your Honor, I believe my time is up. I'm more than willing to.
We'll give you a few minutes in rebuttal.
Thank you, Your Honor.
Mr. Zibin?
Yes, thank you, Your Honor. Good morning. May it please the court. Phil Zippin on behalf of the Appellees. I appreciate how the court has focused its questions on the core issue in this case, which is the manifestation by my client, Occasions Catering, of their intention not to abide by the contract anymore, which had expired under its own terms, but which had gone on for several years after its expiration. The hiring of Joe Guaz is a key and dispositive act in this case. Mr. Mudd's contract, he was the comptroller of this company for many years. His contract required him, the responsibilities were, and I will quote, oversee financial administration for the organization to include management of accounting staff. And it goes on from there with more specific duties. When Mr. Guaz was hired in September of 2017, Mr. Mudd no longer carried out the primary duties of his position. Mr. Guaz supervised Mr. Mudd, who had previously reported to Mr. Michael directly. And as Judge Glickman quoted, there were a number of statements from Mr. Michael in his deposition that made it crystal clear that he was not satisfied with Mr. Mudd's performance in his role as comptroller. He was not handling his job responsibilities adequately for a company that was growing the way Occasions was growing.
And,
So-
but
Well,
to
Mr.
that point, sorry, the company was growing, right? And so there is also evidence that this new employee, this new manager is brought on to do more, and to have, sort of strategic decision-making and oversight, right? So in that circumstance, isn't there at least kind of a factual fuzziness? This doesn't seem analogous to the hypothetical that Judge Glickman posited, where someone is acting as the controller and then suddenly is reassigned to effectively be the janitor, right? This is, he's still in the same area. He's still doing much of the same work, but has some of his supervisory duties redistributed. How stark does the change need to be?
Well, I think it needs to be significant. And in this case, since his primary duty was to oversee the financial administration of the organization and manage the accounting staff, and he no longer did that. I think that's as stark as it needs to be in these circumstances for my client to make it clear that they were no longer interested in having him do the duties for which he had been hired and which were stated explicitly in his contract. So I don't think it needs to be as, I'm sorry.
Well, I just as I have a question for Mr. Greenberg, I have one for you too. So let's assume it's correct that there's no genuine material dispute, no genuine dispute about the fact that his significant duties changed. The fact remains that he keeps his title as controller. He still gets paid the same salary week to week or month to month that he was getting. Nobody comes to him and says to him, you're no longer, we no longer have this deal that we had before, whereby you can expect to keep going on under this implied, in fact, contract that we have here. Nobody says anything to him about that. And what I sort of wonder is this: why is it necessarily the case that this change in duties of the employee by itself, sub silentio as it were, manifests the employer's wish not to be bound by its obligations under the contract?
Well, it's very,
in other words, it seems to me that there is the rule of law here says that the manifest says that what the employer has to make clear and manifest is not simply that your duties are being changed and we're expecting different things of you, After all, employers change their employees' duties all the time, or modify them or what have you. But that we, the employer, no longer wish to be bound, no longer will be bound by our obligations under this contract. And what I am wondering is whether there is still a jury question as to that, even if we posit that the employers, that there's no dispute that his duties did significantly change.
Well, I don't believe there's a jury question. Certainly Judge Pan didn't believe there was a jury question. I think it goes back to the example that you raised, Judge Glickman, which is if Mr. Mudd was told, okay, we want you to be, sweeping the mailroom floor here, obviously that's a major change in his duties and responsibilities. There would also be, quite obviously, he'd be performing at a much lower level as far as compensation goes. So,
I've seen cases where the employer really radically changes the employee's duties, and the employee gets sent to Siberia, basically. But the employer still pays the employee the employee's settled salary. The employer doesn't say, oh, by the way, the employer doesn't say, well, I didn't mention it at all, but surprises the employee later and says, by the way, you no longer were earning the same salary you were getting.
well, I think in this case, Judge, what you have is you have a long-term employee. You have my client, Mr. Michael, who is trying to treat him in a very decent and respectful way, who says, look, we appreciate your 19 years of service. The job has outgrown you. We need to bring in someone who will do the job that you were hired to do, but we're not going to cut your pay. We're not going to treat you in a disrespectful way. And then, of course, there came a point where they said, we have to fire you because we can't have two people doing or being paid for doing fundamentally the job you were hired to do. You are no longer doing it. We're now.
Well, it sounds like when you say, but we're not going to cut your pay. Well, that the implication of that is we're not going to cut your pay. And the argument here is that part of his pay was a profit sharing arrangement. And I think it seems to me like when you say we're trying to treat the employee fairly, it can be argued that, well, it would have been fairer to tell the employee up front exactly what his situation is so that the employee can make a decision. Do I stay here? Do I get out now and look for a job? By leaving the matter up in the air, there's some uncertainty about whether he's going to be paid. He can well think, well, my duties are being changed, but they haven't changed my title. I'm still the controller. I still do important work around here. I've been here for 15 or however many years. They love me, and I get along with everybody very well. And I'm expecting my salary to remain the same. They haven't said otherwise.
Well, I think that, I think respectfully, Your Honor, that misses the point of what the law requires. The law requires a manifestation of an intent to no longer abide by the contract. It doesn't mean that salary has to be changed at all. In this case, hiring someone to take over the primary functions of the job is a manifestation. We do not want you doing the job for which you were contracted, that contract that had now expired several years ago. That's what's important. If they pay him the same, if they pay him more, they pay him less, it's somewhat irrelevant to the issue of we've hired someone to do the very job which we hired you to do.
Well, let me say, I understand fully that you can make that argument, and it's not an implausible argument at all. I'm not dismissing Judge Pan's, assessment of it and so forth. But I am wondering whether, nonetheless, this really ends up being a question for a jury.
Well, Your Honor,
whether this was a clear and manifest indication or not.
Well, I would suggest it is not, because there's no responsibility larger, higher in his contract than overseeing financial administration for the organization, including management and the accounting staff. That he was no longer doing. They had Mr. Guadz doing it, which of course they were paying Mr. Guadz whatever they were paying him. So now they have two salaries to do the same job for which Mr. Mudd had been hired and was under his contract. I don't see how a jury would conclude anything but this was a major change in responsibilities and therefore a manifestation of an intent to no longer be bound by the contract. I do want to point to one other issue, Your Honors, and that is we've dealt with the issue of the facts and whether the job duties change in that manifestation. But I want to point out that regardless of how you come down on that question, I do think there's a significant issue of whether this profit sharing compensation was a wage. We argue this in our brief. The point being that the DC wage statute requires that a wage, to qualify as a wage under the statute, it must be monetary compensation owed by an employer. And we contend that this was never owed at the time Mr. Mudd was terminated in February of 2018. He was not owed any compensation. It had never been calculated. The practice of this company, this longstanding practice, was that they did the profit sharing calculations in March after some rather complicated accounting adjustments that went on. And it was only after that point that anyone could reasonably say there was anything owed for profit sharing. This is not his 2-week salary and that wasn't paid. This is something which was only owed and only determined several weeks after Mr. Mudd was terminated. Now, the case that we cited the court to, which I think is very apt, very much on point, is this Bartola versus Whole Foods Market Group, a case from Judge Mehta in the federal district court. And he looked at a very similar bonus plan that Whole Foods had, an employee claiming that he was owed this bonus at the time he was terminated. And of course, the statute in DC is very strict, that if you terminate an employee, you must pay that employee everything that employee is owed as of the day following termination. And of course, the penalties for failing to do that are quite severe. So Judge Mehta said that in a similar situation, he said the defendant did not yet at the time of termination have the data necessary to calculate the bonus for the following fiscal quarter. He then goes on to say that at the time of the termination, the bonus could not have been earned, let alone calculated, because the end of the fiscal quarter was still several months away.
You know, I'm not sure that makes sense to me. I don't understand how, after he's worked for a year, and the full calendar year is over, it can be said that he hasn't earned the bonus that his contract says he'll be entitled to. He doesn't know its amount. It's yet to be calculated. But whatever the calculation proves to be, he's clearly earned it, assuming the contract is still in force.
Right. What I would suggest, Your Honor, and if I may, I'm just going to quote one more quote from Judge Mehta. He says, the money was not earned as of the employee's departure date. It defies logic to suggest that defendant could pay money that was not yet earned or even calculated as of February 15, which was the day that defendant was legally obligated to pay any owed wages. So
That's very funny. I mean, so you really think that if the CFO had never been hired and Mr. And the year is ended, and that the company could say to him, well, despite this contract, could say to Mr. Mudd, despite this contract, this is not a wage. We don't owe it to you. You haven't earned it. Forget about the provision of the contract.
Right. I would say it this way, Your Honor.
You have a contract claim, you would say, but not a wage claim.
That's exactly what I would say. A wage has to be, as defined by the statute, has to be owed as of the date of termination. How can it be owed?
Okay, can I follow up on that question? Say it's very clear, there's a profit sharing agreement. The employee has worked for the prior year. The employee has worked for the prior year. The employee is making noises about, retiring or moving on, and the accountant still hasn't calculated the precise amount of profit sharing. And the employer says, well, this guy is leaving, so let's just wait till he goes. And then we'll ask the accountant for the report. Can they do that?
Well, I would say.
I mean, the figures are there. It's just they don't have the report from the accountant in hand. You're saying that the employee hasn't earned the money under the clear terms of the agreement. In my hypothetical, there's no question that he's entitled to profit sharing under my hypothetical.
Right. I would say it's not owed until it's calculated. How could How could it be
Right,
fair?
but you were citing the federal district court decision, right? A trial court decision saying that the money isn't earned.
It's not earned. Well, that's what Judge Mehta found. I would argue.
I understand that.
Owed.
I'm trying to wrap my head around that.
Right. I would say it's not owed, whether it's earned or not. I'm not quite sure how it comes down on that, but it's certainly not owed until it's calculated.
And so the employer can wait it out, can do this
Well-
kind of game where they say, well, we're just gonna, tell the accountant to take your time.
Yeah, I think, first of all, that would be totally unscrupulous, and it didn't occur in this case. And what I would also say is the employee would still have a contract claim, would still say, you owe me under my contract. It just might not qualify as a wage.
But I'm thinking, yeah, Mr. Zippin, I'm thinking that there's a distinction between something being owed and something being capable of being paid. It may be why isn't it not true that the employee can say at the end of the year, I've worked for a full year. My contract says I'm entitled to share in the profits, whatever they are, at X%. I am owed that X%. Now I understand I will not get it until a date certain, and you will not be obligated to pay it to me before a date certain, but I'm still owed it.
Well, that the employee can claim that, but until it's calculable, it doesn't exist. It may be nothing. And Mr. Michael had,
I don't know what I'm owed in the amount.
well,
I am owed a percentage of the profits. Well, that seems how one would normally speak, doesn't it?
well, yes and no. I mean, I would put it the other way. I would say if the employee leaves and says, hey, I'm owed my bonus, even though it hasn't been calculated yet, and he files suit the next day and the judge says to him, well, how much are you owed? He says, well, I don't know. How would that even be enforceable at that point in time as a wage until there's some definitive amount that he could say, here's the amount that I'm owed?
Well, you often get rulings requiring in which the ruling basically says the employer must calculate the amount owed. That remains to be done, but you're liable. I don't know why that doesn't sound odd to me.
Well, I would go back to my distinction, Your Honor, which I think you pointed out, which is that I would not quibble that it's a contract claim, but I would quibble whether it's a wage if it hasn't been earned and owed as of the time of termination.
Okay,
If you have any further questions, I'm happy to respond. Otherwise, I will rest.
thank you.
Thank you.
Mr. Greenberg, we'll give you a couple of minutes.
Thank you, Your Honor. I think I'll address two of the points that were just discussed at length. First, in response to Judge Glickman's discussion about the change in duties. So again, it's appellant's position that his primary duties had not changed, and if anything else, there appears to be a material dispute of fact over that. But that being said, even if the court were to find that his duties did change, the conduct that demonstrates a clear and manifest intent to no longer intend to abide by the terms of employment agreement has to be that which expressly contradicts the terms of that agreement. In this court appears to have only addressed specifically what that would entail in its decision in Pitt versus DC Department of Corrections. And in that case, the court found that evidence of specific disinclination to follow a collective bargaining agreement's provisions was enough to show no longer intent to be bound by that agreement's terms. And that was done by the evidence showing that a new union expressly did not want to abide by the CBA's terms, and that the employing agency told its employees to use a different policy procedure than that was in the CBA. So that is a sort of conduct that this court has previously approved to show clear and manifest intent. And just changing the duties, even if just changing some duties, I do not believe shows both clear and manifest intent that the parties no longer intend to abide by the terms of the agreement, especially where Mr. Mudd did continue to work, continue to get paid his salary, continue to have his title, was never told that his salary was going to change in any way, shape, or fashion, was never provided the notice of change in his pay rate as required by the wage law.
He
And
didn't
his
think the
employer,
handwriting was on the wall.
I'm sorry, Your Honor.
Didn't think the handwriting was on the wall?
I don't think so. He, as Judge Easterly noted, the company's growing. The company is growing and expanding, so they hire a new employee, take on this new position, to take on new duties that were not Mr. Mudd's responsibilities. And so I don't think that there's evidence that there was, I guess, writing on the wall. And then, Your Honor, in response to Mr. Zippin's discussion about, I guess, his claim that the wages weren't earned, the employment agreement is clear. These profit sharing is to be determined at the end of the calendar year and paid by the end of February the following year. And that's an express language of the agreement.
Does the statute contain a requirement that the wages be paid within a specific time?
It does, Your Honor. And
What does it say?
it says for employees who deal with our financial employees like Mr. Mudd, that the employer must pay owed wages within 4 days of the end of
4 days of what?
of the end of the employment. And in this case, not
Now,
only,
what if that's simply not something that can be done?
well, Your Honor, under these facts, it certainly could have been done. There's record evidence that Mr. Mudd provided all the information needed for the account to determine what these pre-tax earnings were. And in addition to the 4 days provided by the statute, in this case, the company had 3 weeks to put its house in order and find out how much it needed to pay him. They gave him the 3 weeks notice consistent with the
Well,
term.
suppose it couldn't have been done because the accounting is complicated and there's a question of how to allocate expenses between multiple companies and so on and so forth. And it's a complicated job.
Then,
And
Your Honor,
traditionally, it's always taken more than 4 days, more than 3 weeks, whatever.
then Your Honor, the code
Still
does,
wages- Is it still wages within the meaning of the act?
yes, Your Honor, and the code does provide an employer an out if, for whatever reason, they need more time, I suppose, if they know wages are owed, but perhaps need more time to, I guess, calculate it, which I don't believe are on these facts. So DC Code 32-304, or sorry, 1304, permits an employer to pay a portion of what is owed and thus not subject to liability for that amount. And just if there's anything above that amount, that would be the remainder of amount at issue if the employer were to bring a claim against it for that owed. So if in this case, which are not the facts here, if an employer were to say, I know I owe you some portion, I still need time to calculate it, but I know you're at least owed X.
Is it your position that the employer violated the Wage Act in prior years by paying the bonus outside the statutory time limit?
Your Honor, the statutory time limit of the 4 days is upon termination of employment. So there would not have been that triggering mechanism in previous years. And then, Your Honor, as it relates to Appellee's reliance on the Bartello case, those facts are entirely different here. In that case, the employee was terminated in the middle of a quarter and asserted that he was entitled to a bonus based on some performance for the quarter in which he was terminated. And the court rejected that claim because it could not have been earned or calculated by the end of the fiscal quarter, which was several months after the person was terminated. In this case, Mr. Mudd's owed profit sharing compensation was based on the company's pre-tax earnings from the calendar year prior to his termination. And so Mr. Mudd's earned wages were readily calculable at the time of his termination and the 4 days afterwards. And if there's anything further, appellant requests, again, that the trial court be reversed and judgment be entered in his favor, or alternatively that the court remand it for a trial on the merits.
Good. Counsel, thank you both. The case is now submitted, and you may log out.
Thank you.
Thank you.
Bringing in the next case.
Okay, we will call the next case, RFB Properties versus Deutsche Bank Trust Company. Counsel, thank you both. The case is now submitted. And you may log out.
Thank you.
Can the parties who are not arguing mute their mics?
Use their mutes.
It appears that Mr. Mandia is still, is not muted.
You know, we do not have a visual yet for Mr. Mandia. Are we going to get one, or are we going to be speaking to us without the visual?
Yeah, I'm trying to get it to go on. I'm not sure why it's not. It worked perfectly fine the other day. There it goes. Sorry about that.
Oh, good. Okay. All right. We may proceed. Counsel?
May it please the court? Peggy Marquardt for appellant, RFB Properties 2 LLC, plaintiff below. I would like to reserve 3 minutes for rebuttal if I may.
You may.
Thank you. The primary issue to be decided on this appeal is whether the trial court erred when it granted summary judgment to appellee on the basis that the purchase price of the property at the condominium lien foreclosure sale at issue in this case was unconscionably low as a matter of law and sua sponte set the sale aside. In so holding, the court made a number of errors that require reversal.
Why do you say she did it sua sponte? Wasn't this argued?
Your Honor, the court actually set aside the sale. This claim of unconscionability was never pled by the appellee. It was
I see, but it was subsequently argued before she ruled.
They requested that on the basis of unconscionability that the claim be dismissed against them, but nobody ever actually made an affirmative request to set aside this foreclosure sale. That was never, and frankly, it just wasn't properly pled. There should have, if you're moving to set aside a foreclosure sale, we would submit that a proper party would have been the condominium association, who was the party that actually conducted the condominium lien sale. So I believe that this setting aside of the condo sale was outside of the scope of the pleadings and was outside the scope of the motion for summary judgment.
Okay, so the difference is that the bank was just saying, dismiss this request for declaratory judgment. I guess I'm just trying to figure out sort of the effect of doing one versus the other.
Again, Your Honor, I think the fact that this wasn't properly pled raises a number of issues, which is why.
Well, can I just drill down into my question? I'm just thinking this through. So, right, RFB was coming to the court to say, please recognize our ownership interest in this property. And if that claim is rejected, then the bank is the one that has the recorded deed to the property. So I'm just trying to figure out sort of as a practical matter, what difference does it make whether the court actually purported to set aside the foreclosure sale or just dismissed your complaint?
I'm not quite sure what the effect of it would have been, Your Honor, and I think that's part of the problem is again, it wasn't properly pled. And so we were unable to raise a number of defenses and a number of issues with regards to the unconscionability claim. And so I'm not sure. I think that's another lawsuit that was just never properly raised, and how that would have played out, I'm not sure, again, because we just don't know.
Okay, maybe I'll come back to this. But so moving on to unconscionability, if I understand the way this issue was litigated and ultimately decided, the parties and the court, the trial judge, agree that unconscionability is theoretically a basis for setting aside a foreclosure sale on a condo lien. And the trial judge theoretically agrees that if a property is bought subject to a mortgage, that is relevant to the unconscionability analysis, right? And maybe even she goes so far as to say, if the property is in fact subject to the mortgage, then the sale, the purchase of the property for $50,000 is not unconscionable. Do you agree with those things so far?
I don't think that the issue of unconscionability of purchase price has ever been litigated in the context of a condominium lien foreclosure sale in this jurisdiction. And that was something that we pointed out to the court in the oral argument, is that this was an issue that hadn't been raised in this context before.
So RFB has not conceded that unconscionability, even though Chase Plaza and 4700 Connecticut Avenue say an unconscionability challenge could be brought. You're not conceding that?
I'm not sure that that's what either of those cases say necessarily. I think that they referred it wasn't litigated at all. So I don't think it was addressed at all. So whether it could be raised as a defense and whether it had merit and whether or not it could properly be raised, I think was an issue that hasn't been adjudicated. And I think
wasn't one of them remanded for that purpose? I can't remember, but it's in my brain somewhere.
I believe actually, Your Honor, that both may have been remanded to address the issue because it was raised as a defense, but I'm not sure that the argument went to the length of saying or analyzing that it was actually a proper defense to a suit in the condominium lien context. I just don't.
Okay, I'm not trying to back you into a corner, but I'm just trying to get to what I think is the crux of the issue here. The trial court, it seems to me, her analysis turns solely on an issue of timing. If I'm understanding this correctly, she is saying, sure, if you're buying property, if this property had been purchased for $50,000, subject to the first deed of trust now held by Deutsche Bank, then held by their predecessor in interest. If those were the facts, I would not find this sale unconscionable. But I'm not looking at it at the time of the sale, the foreclosure sale on the condo lien. I'm looking at it at the time of this litigation. And we now know that the property is not subject to the first deed of trust. There's no encumbering mortgage. And so therefore I'm finding that the property is, the purchase price was unconscionable. Do I have that right?
I think you do, Your Honor.
Okay, so it's just a question of timing, really. And I guess the court seemed to be looking for law on when she should assess the timing of the unconscionability question. And did RFB or the bank provide any law on that question?
I don't think that the bank presented any law on that question. I think that if you look at the law in our jurisdiction and the cases that from our own court in Jackson versus Fuller, versus Lewis versus Jordan, which is 725 A second 495, which is a DC Court of Appeals case from 1999, specifically says that there is no hard and fast rule as to when a sales price for a property is shockingly low. And Jackson versus Fuller, which is a DC Circuit Court case that was referenced by Lewis v. Jordan, specifically says that each case must rest on its own facts. And when you're looking at the facts of each sale, you have to look at the facts that existed at the time of the sale and not.
But that doesn't, saying that you have to look at it on its own facts doesn't tell you look at the facts at what point in time. I mean, I have to say, I agree with you that there is case law out there that answers this question. I just don't see that either party cited it to the trial judge. So, you know, it seems to me that it's actually quite clear in our jurisdiction that you look at unconscionability, you look at the circumstances at the time of the sale. That is settled law under, under our case law around the country, in the treatises. It's in this restatement for contracts. And I'm just trying to figure out why none of this was ever cited to the trial judge.
I think, Your Honor, that I think that the case law that we cited indicates that the factors that were considered existed at the time of the sale, but I'm not sure that we were able to find a case that specifically dealt with this issue of a fluid law at the time of the fluidity of a law at the time of the sale that should be.
What does the fluidity of the law have to do with it ultimately, I guess? Maybe that's where people went astray, right? Because it seems to me that RFB's argument was, we purchased the property subject to the first deed of trust. I don't think that the sale papers are in the record, but at least the advertisement for the foreclosure sale is in the record, and that says something about the first deed of trust. So maybe there's an issue of fact as to whether or not that it's in the actual foreclosure sale papers. But that was RFB's argument. And if that is the case, then, there are just lots of cases that say, I'm looking at a case, Kenyon Limited Partnership from our jurisdiction from 2009, that says that whether a contract term is unconscionable is determined as of the time of the contract, that the time the contract is made, right? And there, folks were trying to challenge a tenant's purchase agreement for property, and the court said, no, you're looking at circumstances as they developed after the contract was executed. So that seems to squarely support the question that the court was grappling with, but didn't get any guidance from the parties on as to what point should unconscionability be assessed. So do you think then is this a question really about the uncertainty? Is this matter as to the state of the law? Does that make the question less clear?
Well, I think, Your Honor, that we were focusing on presenting to the court a number of factors that would have affected a purchaser at the sale and would have affected the purchase price down. And one of those factors was the fluidity of the law at the time and whether this property, whether this purchase would have been subject to the deed of trust, and additional factors that we would have presented to the court that would have shown what a reasonable purchaser at the time of the sale would have been considering in making their offer, and which would have affected the purchase price of the property and would have affected the bid price at the property. And frankly, it's our position that no reasonable purchaser would have made a higher bid at this sale, given all of these risks that they were taking at the sale. And so that was, I think, what a lot of our argument, what we were focusing on.
What it comes down to, if I understand correctly, is that Judge Pan assumed that we look at what the property would bring at a foreclosure sale now after the cases of Lou and Chase Plaza and what is it, the 40, I forgot the number,
4,700 Con.
4,700 Con have been decided. But back at the time of the sale, Chase Plaza had been decided, but not Lou and 4,900, and there was 4,700, 4,900.
That Lou had been decided and 4,700 Con had not been decided.
Lou had been decided, but
Lou had
4,700.
been decided, but 4,700 Con was decided during the course of the litigation.
And as a result, the calculus that people would have gone through at the time would have been different. What about the fact that they did know that Chase Plaza and Lou had been decided?
I'm sorry, Your Honor, just to be clear, at the time of the sale, only Chase had been decided, not Lou had not been decided. I'm sorry,
That's what
I
I thought.
misunderstood.
Okay.
Yes, that's correct.
Only
Chase-
my thought had been only Chase Plaza had been decided. Well, didn't
What-
Chase Plaza put people on notice that this property is worth a lot more at that time than it went for because the first mortgage would not be enforceable?
I don't think so, Your Honor, because it wasn't until the Lou case was decided that the court determined that the actual language or that the condominium couldn't make its lien, that couldn't opt to make its lien inferior to the first deed of trust. And it wasn't until 4,700 Con was decided that whether a sale that was in excess of the 6-month super priority lien would be treated as a split lien with partial superiority, or whether it would be treated as one lien, where the whole lien would be treated as inferior to a first deed of trust. So I don't think.
Putting aside what 4,700 Con clarified, was it clear at the time of the foreclosure, or was the foreclosure in this case explicitly subject to the first mortgage?
Well, the language of the advertisement states, Your Honor, and this is on joint appendix.
You just froze.
It just froze. Joint appendix what? Oh, it froze again. Ms. Marquardt, I apologize to you. We're having some trouble. You froze on us for a minute or two. You're back now.
Am I back now, Your Honor?
You're back now, but we didn't get the JA page number.
Yes, JA 19 shows the language, or shows a copy of the advertisement, which states that the purchase price must be paid in cash. Unit 913 shall be sold subject to real estate taxes, if any, and shall also be sold subject to any other superior liens, encumbrances, and municipal assessments, if any. So I think that, again, that it makes it unclear at the time of the sale for anybody who is making an offer on this sale, whether this would have been taken subject to the first deed of trust.
Okay.
And there are additional factors as well, I think, Your Honor, that distinguish a condominium lien foreclosure sale from a standard foreclosure sale of a first deed of trust, especially in this context. And those were some of the items that we were trying to point out to the court that would have affected the purchase price down. Frankly, a condominium lien sale is carries considerably more risk to a purchaser than a standard foreclosure sale of a deed of trust.
I'm sorry, go ahead. I don't mean to interrupt you.
For example, and these were items we tried to point out, for example, the inability to obtain title insurance and the inability to ultimately sell the property because of the inability to obtain title insurance. So these were some of the items that we were trying to show.
One other question that I have for you is it correct that Deutsche Bank's Assignor, its predecessor in interest, was aware of or informed of the foreclosure sale?
I think at a minimum, Your Honor, they were.
You have just frozen us. I don't know whether you can hear us. You froze on us again. As you said, they were at a minimum, and then we did not hear the rest of your answer, and I'd like to hear it. So.
I apologize if this is coming from my end, Your Honor. At a minimum, the predecessor must have been on inquiry notice of the sale. There was a notice of condominium lien foreclosure sale that had been recorded amongst the land records. But in addition to that, the deed of trust itself, of which they were the holder, contains language that requires the condominium lien assessments to be paid into an escrow account that was held by the holder of the deed of trust. So they must.
See, I don't think either of those things puts the first mortgagee on notice of a foreclosure sale.
What about the fact that you purchased it, sorry, for $50,000 and I thought that they were only foreclosing on $36,000. What happened to the balance? That should have gone to the bank. But is there any evidence that it did?
I'm not sure of the answer to that, Your Honor. I don't know. I don't know whether that balance was submitted to deed of trust holder or not.
I guess none of this has been litigated, right? The inquiry notice hasn't been litigated, but it certainly would be interesting to know what happened. I guess you purchased it for $53,000. So, if the predecessor in interest suddenly gets a check for $17,000, one might think that they had a duty to inquire why they're getting that check and maybe whether or not the property has been sold.
I would agree with that. I would agree that would certainly put them on inquiry notice.
But the record doesn't indicate how the proceeds of the foreclosure sale were disposed of.
I'm sorry, Your Honor, I just don't recall the answer to that. And
do you recall whether Deutsche Bank, in complaining about the unconscionability of the sale, made any claim that its predecessor in interest was not advised of the foreclosure or informed of the foreclosure sale?
They indicated, I believe, at the hearing that their client, they proffered that their client did not have actual knowledge of the sale.
See, that to me, I pose that question because that fact, if true, it strikes me that may make a difference in deciding whether the foreclosure sale was or was not unconscionable. Because we rely on the absence of any sort of unfairness, to people who would have an interest in the outcome of that foreclosure sale, in deciding whether it can be overturned or not. And that to me might be a significant factor. Do you think so?
I think it may be, Your Honor. I would submit that we take the position that they were on inquiry notice, but I do think that perhaps had that been litigated.
Do you really think that just putting something in the land records puts and what was the other thing you cited? The fact that they were supposed to. I'm sorry. So they weren't living up to their duty to escrow 6 months worth of condominium fees.
All of the condominium assessments.
Oh.
So they say they must have known the assessments weren't being paid.
But by you're talking about the predecessor in interest, right? Because Deutsche Bank comes along later.
Yes, the predecessor, but Deutsche Bank took from the predecessor, so they would be standing in the shoes of the predecessor. But yes, the predecessor.
I mean, it just seems to me that all of this needs to be possibly litigated down the road, but I'm wondering which way that cuts if Deutsche Bank is the successor in interest, right? They decide, do we want to assume this, take over this property from the predecessor in interest? And presumably they did some due diligence before they did that, but I don't know. I mean, it just seems like none of this has been litigated.
I agree with that, Your Honor. And I think that's part of the problem is none of this has been litigated. And I think that had they made a proper inquiry, then they should have been aware of this when they took the deed of trust as well. But again, I agree, none of this has been litigated, unfortunately, because this went on a summary judgment motion.
Well, I don't understand why you say that. I mean, Deutsche Bank has made a showing in its brief to us that RFB had ample notice that this issue was being raised. And I'm not aware, did RFB ever file a Rule 56F motion with the court to permit more discovery? I don't know the answer to that question.
The answer is RFB did not file that motion, Your Honor, but we did include throughout our briefs on this issue that we desired the ability to put on an expert and the ability to conduct additional discovery in the court.
Well, what stopped you?
The court rejected that argument on hearing, indicating that she didn't think that these additional issues weighed in on the issue of whether or not the purchase price was unconscionably low. So there was actually a
No,
dialogue.
wait a minute. I mean, did you attempt to take specific discovery that was objected to? Did you attempt to call a witness or present an affidavit, or I don't quite understand in what sense you were prevented. Now, I can understand if you said to me you weren't able to take discovery, but that's why I asked whether you filed a Rule 56F motion.
So at the time of the motion, Your Honor, the deadline for discovery and the deadline to submit a 26A2B report had already expired.
Right, I'm sure it did.
So these issues hadn't, and we had actually inquired as to the issue of unconscionability. Well, not specifically, we had inquired as to what their defenses were or what their factual.
That came earlier. Let's assume it's true that it was only later that you became aware that they were raising an unconscionability claim, and it's in connection with the summary judgment motion. Well, if you think that that you haven't had a chance to take appropriate discovery on that, then you try to take it, and you do your other investigation, and you get an expert and so forth. And if you're not able to, if you're having problems, you file a Rule 56F motion.
So the court.
I wonder whether you waived any discovery claim, frankly.
So we raised it throughout our pleadings, and we actually did address it with the court, and the court rejected our position that we needed additional discovery, saying she didn't think that it was necessary. So there was an exchange between my colleague and the court at one of the hearings where she actually asks, and this is on JA 513 to 514, and the exchange is, I'm just trying to understand how the discovery affects this, because the facts that appear to be relevant are not in dispute. And I'm just trying to understand what you're saying additionally needs to be known. And my colleague indicated, well, we would put on an expert. And the judge said, but that assumes that a certain reading of the law that I might not agree with, because I think I'm deciding this case today, and you think I should decide it as of the date of the purchase. And I think as a matter of law, you're not right, and that wouldn't be relevant. And so the court actually had rejected our position that we needed additional discovery and the opportunity to submit an expert in order to fully explore this issue.
And that's because the court
stage
thought
was this?
the timing issue was the dispositive issue, right?
Yes.
So had the court understood that actually the black letter is look at the unconscionability of the purchase of the foreclosure on the condo lien and the purchase price from that transaction at the time, then maybe her discovery rulings would have been different because she would have understood that they were relevant. But because she was saying none of that matters, we're just looking at unconscionability now when we know this property is not subject to a mortgage, and $50,000 for a $500,000 property free and clear, that's just not a legitimate price. Is that what happened? I need to go back and look at this record.
So I think that think that we did argue to the court that by looking at this at a later time, that was referring to this issue with 2020 hindsight. And so we made the argument to the court that that the court should not look at this from the perspective of the time of the motion. But to answer your question, Your Honor, I believe that she disagreed with that. And so that is the reason that she did not agree with our indication that we wanted to put on an expert and seek additional discovery here. But again, we did make the argument below that the court would need to look at this sale from the point of time of the purchase of the sale itself.
What I guess I just don't understand is why, in response to the summary judgment motion, you didn't file something that said, look, the value of this property is in dispute. Here's our expert testimony. Here's what it would say. Here's other facts that we think bear on this, and you make your record.
Again, Your Honor, this was raised on dispositive motion after all of these deadlines had already expired,
Nothing stops you from going out and hiring an expert and having the expert prepare an affidavit. And if somebody says, well, you didn't tell us about this expert before, your answer is, well, you didn't tell us this issue was going to be in the case before.
Well, I mean, again, Your Honor, I don't think it necessarily would have mattered because the court rejected our argument there about whether or not the expert would have any valuable information to add to this discussion.
Well, there's a legal question here. Right. I agree with that.
If I may, I'd also I know that my time is short, but I'd just like to point out also that I think the court erred because she specifically adopted the restatement's 20% guideline. And that was the sole basis for her ruling. And our court has specifically rejected adopting that hard and fast rule that of the restatement's 20% guideline. I think the restatement itself has even acknowledged that there are special circumstances that would warrant not invalidating a sale even when it rendered a price lower than 20%. And I think that there were certainly special exceptions in this case. Again, much of the conversation regarding this area of unconscionability deals with the foreclosure sale of a first deed of trust or a deed of trust, and not in the arena of unconscionability as it relates to a condominium lien foreclosure sale, which again bears markedly more risk than a standard foreclosure sale, especially under the old statute pre-Liu and pre-4700 Con. And so I think the court in relying.
Sorry, you just said that was the 20% figure was the sole basis for the court ruling, but that's where we started. I was actually trying to figure out sort of what the fulcrum is on which this case, balances, and I thought it was the timing issue. I mean, once you resolve the timing issue, then she applies the 20%. But do we even get to the 20% if we say that she was just looking at the wrong point in time?
I think that in order to prevail, appellee would need to show that the court did not err on the timing issue and accepting their values, and that the court did not err when she specifically applied the 20% guideline under the restatements. I think that the court erred under both, and under either theory.
20%, I mean, what I thought that the trial court said was, look, if this property is subject to a 500,000, let's just round numbers, right? If you bought it for $50,000 and it's subject to a $500,000 mortgage, right? Add it up, $550,000. That's not an unconscionable price. That's kind of within the range of the numbers that the bank was giving her. Why does 20% even matter?
I don't think it does, Your Honor. I don't think that the 20% guideline is the proper measure here, but that's the measure that the court relied on. And she says specifically a number of times in rendering her ruling that
So is this your fallback argument if we were to ignore the black letter law and say she was right to look at the timing as, she was right to look at this, through 2020 hindsight? I'm not understanding why we're talking about 20% at this point.
I just think that the court erred on both issues. And so I don't know that I would necessarily call it a fallback argument, but I think that there was multiple errors here that would require a reversal.
Okay, thank you. We'll give you a few minutes for rebuttal. Let us hear from your opponent.
Thank you.
Good morning. May it please the court. I'm Bill Mandia on behalf of Apple Lee. And I want to start by addressing the questions about the court and the issue of timing. I think that the proper context through which this has to be viewed is in the case law dealing with sort of forced sales, and what that case law says and what the restatement says about forced sales. And what it says is that the unconscionability measure is really a matter of looking at what is the fair market value of the property at the time it's sold, as compared to what was paid, right? And the restatement standard is saying, if it's below 20%, the court's well within its discretion to find that the price was grossly inadequate and thus not sufficient and unconscionable.
But I'm sorry, can we just drill down on where we were with RFP's B's counsel? Do you agree that the court was looking at it, decided that the assessment of unconscionability should be decided at the time of litigation, not at the time of sale, and that was dispositive to her ruling? That's why she applied the 20% with the understanding that the property was not subject to a mortgage.
And I believe that is correct, because I think you have to look at what actually.
So I have done research and found, as I said, ample black letter saying that one looks at unconscionability at the time of the sale. Do you have reason to tell me that that is incorrect? I'm looking at the restatement second of contracts, section 208. I'm looking at Williston on contracts, section 18.12. I'm looking at case law from the DC Circuit, which is binding on us because it's from the 60s, so it predates the creation of this court. I'm looking at case law from our court subsequent to the creation of this court. They all say you assess unconscionability looking at the circumstances at the time of the transaction, the purchase of property, the formation of the contract uniformly.
And I think in the context of a contract, I would agree with you.
I'm just want to be clear, they also apply to sales of property. It's not just contracts cases.
But not in the context of if there are, I apologize, I'm not aware of them, but I haven't seen any such cases in the context of a forced sale.
Tell me why that's different.
Because the market in a forced sale is completely different than what goes on between two arm's length buyers. If
that may be so, but why does that make the timing issue different? Why would you look at unconscionability after the fact?
Because the court is sitting in equity, addressing whether or not to set aside the sale, and it has to look at the equities of the situation, right?
But my question is, why is it equitable? Why do the equities as they exist years later, why are those the equities as opposed to the equities at the time of the forced sale?
Number one, I don't know that we're looking at the equities years later, because the Chase Plaza case had already been decided by the time that this property was purchased by RFP.
But Chase Plaza didn't make clear that the first deed of trust that was held by the bank was going to be extinguished by foreclosure on a condo lien that was in excess of the 6 month arrearage.
And that's why
I feel like I'm speaking a different language, so I hope that made sense.
No,
but I don't think Chase Plaza said that. And I think the only thing that made that clear was 4700 Connecticut Avenue, which was not decided until 2018, which was after the sale, well, years after the sale.
Sure, but even in that context, that's why you have the 20% rule, right? It's a pretty low threshold that somebody has to get over.
I don't want to get to the 20%. I really do want to stick with the timing issue. And I want to know, do you have any authority to point me to tell me that even in the context of a forced sale, we should not be following the black letter law on unconscionability of the execution of contracts and the sale of property? And we should be looking not at the time, at the circumstances at the time the transaction was completed, but at some later time. That's what I'm looking for.
Yeah, I think all of the cases that address a forced sale, look at it.
What cases are you referring to? Are they in your brief?
Yeah, I mean, we cited, what I'm trying to get at, I know you may feel I'm trying to be evasive, but I'm not. The 20% rule is in you can't, I'm trying to say, I would appreciate it.
I really would like to divide the 20, because the 20% rule in I mean, I'll give you a second to tell me why the 20% rule has any bearing on this, on the timing question, but it seems to me that you have to decide what time are we looking at, and then you apply the 20% rule. So I'm less interested.
Let's give an example. It may be that Mr. Mandia doesn't quite understand the distinction you're drawing. In other words, let's assume, let me give you a simple, simplistic example to illustrate. There's a forfeiture sale, the winning bidder pays a fairly low price. And then when they go in, it discovers, oh, there's gold on this property. I have better examples than this, but I just want to give the, and later on, and after that, after the gold is discovered on the property, everybody understands, the fair market value of this property is 10 times what people thought it was at this fair and above board foreclosure sale. It's shockingly low, that price. I bet you would not say, under those circumstances, that the purchase price was unconscionable, and with all the consequences of that, of saying that. Am I right? And you wouldn't say it. And you wouldn't say it because what people thought because what's relevant in determining the unconscionability is not what we know now about the fair market value, but what was reasonable to think about the fair market value, or some other value, if the fair market value is not the best measure, at the time of the sale. Right? Or would you say that the discovery of gold would allow, the former owner who lost the property at the foreclosure sale to come in and say, wait a minute, let's do a duel?
I think that's a different example because it's a completely.
Well, I'm not sure it is, but I gave it only to illustrate, to make clear to you the point that I think Judge Easterly is making, which is, forget about whether it's 20% or 10% or 0% or whatever. We're making a comparison. The unconscionability inquiry makes a comparison. What the judge did, what Judge Pan did, was say, I'm comparing it to what we now know under the law now is the appropriate value of that property. Whereas Judge Easterly is saying, no, you got to look at how people thought about it back then. Do I have that right, Judge Easterly?
Yes, and just to follow up, I mean, what I hear you saying is, sure, that's the rule generally. So to take Judge Glickman's hypothetical, right? I own the property. I sell it to Judge Glickman. Suddenly, gold is found on the property, and I go back and I say, there's gold on my property. You bought this for an unconscionably low price. I want more, right? And I'm trying to undo the sale. And the question is, well, who knew about the gold when, right? And it's at the time of the sale. What I hear you saying is, well, it's different if it's a forced sale. And I'm trying to understand, okay, so I own the property and I've got a mortgage on it and I can't pay the mortgage and the bank forecloses on it. And then Judge Glickman buys my property and finds gold on it. And then I come back and I say, that was an unconscionably low price. You found gold. And I'm trying to figure out why the forced nature of the sale makes any difference in the timing of the unconscionability analysis.
Because, well, no, I mean, because it's in the context of a forced sale, you're not having the arm's length transaction that you have in your hypothetical between you and Judge Glickman, where you negotiated a purchase price and everybody took it and said, okay, this is what we thought fair market value was. We negotiated this deal at arm's length. In the context of a forced sale, you're buying an unknown, right? And the courts recognize that in order to promote efficiency in the forced sale context, there has to be some leeway there, right? You can't come in and just say, oh, well, it was a bad deal or this or that. The question is, was it really grossly inadequate? Sufficiently low such that it should be set aside. And that's why the 20% threshold in the restatements there.
Sufficiently low, wait, let me stop you. Grossly inadequate compared to what the property would have sold for back then if it had not been a forced sale, or what the property would sell for knowing it had not been a forced sale.
Well, I think you look at the fair market value of the property at the
Because
time.
the point that is being made is that back then, even if it had not been a forced sale, and it had been a complete, fair, arm's length transaction, the property would not have gone for the kind of money that Judge Pan was positing, because back then, people would had all this concern about the first mortgage in the background.
But that's the price that it would have went in the context of a forced sale, which isn't the standard. The question is, what's the fair market value versus the price of what was paid in the forced sale, right? If you look at the BFP case from the U.S. Supreme Court, I think
So wait a minute. So what you're saying, in effect, is something different. You're saying we should disregard the first mortgage, the influence of the first mortgage, because we don't care what a reasonable purchaser in a fair transaction would have paid back then. What we care is the absolute value of this property. That can't be right. It's encumbered.
Well, if it's in fact encumbered, you need to back out the
Well, people thought it was
value of the mortgage. I'm not disputing that, but the question is, I think there's a presumption here that people thought it was going to be encumbered, and I think what the best argument that RFB has is people didn't know if it was going to be unencumbered or not, right?
Do you think if they don't know and they factor that in, that can't affect the value, the fair value?
It wouldn't affect the fair market value. It may affect whether or not the price is unconscionable. And I think Judge Pan concluded that at the end of the day, that price was sufficiently low.
Well, wait a minute, I don't understand that. I guess let me give you another hypothetical. Suppose people know that before the zoning commission, there's all sorts of litigation going on that could affect the value of this property. And they even know that. They don't know what it's, they don't know how the zoning commission has come out. So we have a forfeiture sale and a very low price, and the property goes for a very low price because nobody wants to be aggravated with all that zoning headache. But then it turns out afterwards that the zoning commission decides the case in a way that really shoots up the value of that property on the fair market value of that property. And the winning bidder says, I don't know, through luck or foresight or, dumb luck or whatever, I got a really good deal, as the trial judge said. And I got something that's worth 10 times what I paid for it. Do you think people can come back and say, oh, in those circumstances, well, wait a minute, that's so shockingly low, it's unconscionable?
Absolutely not.
If you think absolutely not, I don't see why you think this case is different.
It's different because in that instance, and even in the fair market, the value of the property is going to be subject to the uncertainty surrounding the zoning thing that you're talking about. In this context, if the law were such that mortgage was not set aside by this sale, right, then the fair market value of the property is what it would be sold for in an arm's length transaction in the market at the time. It would be subject to the mortgage. I agree with you on that point. I'm not trying to disagree with you, and that's the measure that you have to use. So even if you want to go back and look at the time, the question then is, okay, what was the property worth at the time, less what was owed on the mortgage compared to what they paid? And then you have to contemplate, though, you'd have to say, you can't say for sure that that mortgage was going to be enforceable at that time.
But
because
didn't
there was
Judge Pan make a
uncertainty.
finding that it would have? I'm looking at the appendix at 448. I mean, maybe she didn't make a finding, but she said, if I had to make a finding about what people's expectations were on the day of the sale, the foreclosure on the condo lien sale, I think I would have to find that people are expecting this to be subject to the first deed of trust. Because if you assume that markets are efficient, this thing would never have sold for $53,000 unless people assumed it was subject to the first deed of trust. And again, going back to what my colleagues and I believed the law to be before Lew in 4700, we believed it would be subject to the first deed of trust. And that's why my colleagues got reversed in Lew in 4700. I think we got reversed in Chase Plaza too. Everybody was thinking, these are subject to the first deed of trust. The only thing that's super priorities in the first 6 months, the rest are subject. And then she gets cut off. But she's saying that's what everybody thought back then.
And look, I mean, that's.
And then she just says, but we're not looking at what everyone thought back then. We're looking at what we know now. And I think that as a matter of black letter law, that was incorrect. I think that she was not given the black letter law. So, she made an incorrect ruling.
And I think that, in this particular context here, and I mean, I'm not here to argue with what she said on the record. She did say that. I think at a minimum, you have to then look at, how would that uncertainty of the law affect the value of the property in terms of your unconscionability analysis?
But I guess what I'm saying is, I think she made a finding that the law was not uncertain. Do you disagree?
That issue wasn't litigated before. She certainly said that's her view of it. And maybe if we did litigate it and argue that issue, she'd find it that way.
Did you push back against her statement when she said this is what the law was back then? This is what everyone understood back then?
No, but she was also, I believe at that point, and I could be in the wrong part of the record, she was reading her opinion from the bench, and I really wouldn't be in a position to say that. I'm not suggesting to you I would, but I was, we were listening to her, what her ruling was at that point. So it really wouldn't have been appropriate to interject myself at that time.
May I ask you another question? Something else I don't understand, I guess, about unconscionability doctrine. I think I don't quite understand why one would say that in a perfectly fair and above board foreclosure sale, let's assume that's true. Let's assume there's no procedural problems in any way, no, fraud, no whatever, no misrepresentations or omissions. It just happens that somebody gets a really good bargain. The purchaser buys something and it's a very shocking, you could say, I don't know what shockingly means, but a shockingly low price. In the absence of fraud or other procedural fairness, why is it that the fact that the purchaser just got a very low price, why is that a basis for saying that this was unconscionable? I have a problem with that in abstract principle. And I realize the law is solicitude for people whose property is being taken away from them in a forfeiture and the powerlessness they may have to protect their own rights and so forth. But, throughout our market economy, people all the time get the advantage of the bargains they make. You go to, this may be a silly example, but you go to an antique store and the antique dealer has all sorts of, stuff that the antique dealer basically thinks is junk. And sells for a very low price. And the really shrewd buyer who comes in and can recognize a Chippendale, I don't even know what these things are, a Chippendale chair, and buys it for a pittance. The dealer and nobody else can come back to the purchaser and say, hey, wait a minute, you really got that chair at a unconscionable price. You paid 1/1000 of what it's really worth. That's the market, absent some degree of fraud. Why is it different? Why would we think unconscionability applies here, absent some sort of, unfair dealing?
Yeah, I think it's here, and again, I think it's a fairly low bar that's set to overcome it, because of things like particularly the statute that we're dealing with here, right, which only required, I think, constructive notice through publication. It's some measure of backstop protection.
It's not, the dealer went into it knowing, nobody forced the dealer to put the junk out there.
Right.
Here it's a for sale, but I wonder if that makes a difference. I mean, nobody forced the previous owner to enter into a contract that the owner, mainly the pay mortgage, that the contract couldn't fulfill, that the owner couldn't fulfill. So I wonder whether that really should make a difference. I mean, I realize that is the
Yeah, and again, I think particularly in this context, it's important where that first mortgage lien holder isn't getting notice of the sale actual notice. There's constructive notice, but that's a difficult bar to meet, and perhaps
Well, that surprised me a little bit because from Lou and I haven't thought about this in a while, but I thought the notion, or part of the notion behind the super priority lien, was that the first mortgagee has ways to protect itself. And usually I think it's by escrow perhaps, or paying, but I thought part of the ways was ways that a first mortgagee can protect itself is by bidding in on the property if necessary.
And again, if it knows that the sale's going on, and I don't know at the time, and I didn't admittedly, because the law was settled on this issue by the time. I don't know if at the time the statute was passed, the assumption was that it would be interpreted that the first priority lien was going to survive outside that 6 months. And that, I'm not saying that in any way to suggest this court's wrong. I just don't know what the legislature
That was an issue. That was an open
was thinking at the time. And so I think in this context, notwithstanding free markets, and that unconscionability protection, it serves an important purpose, like as a backstop. And again, it's a relatively low bar of 20% there that you have to overcome. So you have to show someone really got a great.
Well, one thing I'm wondering, especially given what Judge Pan said, is whether we should remand this case and say, look, you've got to apply the law. The question you've got to ask is what reasonable buyers and at a forced sale back then, under the knowing what they knew and didn't know at that time, would have paid. And that's what you compare the actual price that was paid to.
I think if it were remanded, what you'd have to compare it to is, you'd have to do some kind of fair market value analysis, and maybe you can't take it outside of the forced sale context because of what you're saying with respect to.
But it's the fair market value question, I think, and I don't hear you actually disagreeing, is what would people purchasing this property at foreclosure back then or even in an arm's length transaction back then have paid, knowing that all they were getting was something that might be subject to the first mortgage, and I don't know what other liens there might be.
And maybe we're saying the same thing just in a different way. I think where it would fit in, if you're looking at the restatement framework, it would be in the uncertainty question, right? Which is an argument that RFB has made, where the court then has to exercise its own discretion. The 20%, the restatement says in that context that if there's some uncertainty, below 20% could be, within the court's discretion to find it not unconscionable.
What I read Judge Pan to have said is, I'm not factoring in the uncertainty due to the created by the existence of that first mortgage, because we know now that that first mortgage was extinguished.
Yeah, I think she construed right, and I think she construed the uncertainty to be in the context of you took the property subject to the mortgage, and maybe that's maybe the framework that you're articulating on a remand would be the framework you'd have to litigate this in, which is to look at that uncertainty prong. The example in the restatement's not on all fours. It kind of talks about situations where the presumption is it's being taken subject to a first priority lien, but there's some weird issues with it. Either it's an extremely large amount of the value of the property, or it's got weird prepayment penalties associated with it and stuff like that that could have an impact. So I think, I guess on a remand, the question of unconscionability isn't over. I think the way it would have to be analyzed is we'd have to look at, what is the fair market value of the property versus what they paid for it, and whether or not Judge Pan thinks in her discretion that's unconscionable, even if it's,
Right, so to put it succinctly, what I hear you saying is that you agree that it would be reasonable to remand for Judge Pan to assess the fair market value of the property back then, given the uncertainties that existed back then, to take into account the uncertainties existing back then, which she didn't do.
Well, I guess I wanted to ask, I mean, this just gets back to the quote, the passage of the transcript. Is there really a fair reading that there were uncertainties back then? I mean, had the law actually, had we affirmed what the trial judges determined in Liu and Chase Plaza, then everybody would have said, well, that's the law, right? And she is saying that's what everybody understood. I don't see her making a finding that there was uncertainty back then. I think she's saying, actually, everybody thought one thing back then, and now we know the opposite.
But
So I guess my question is, I mean, I understand, there might be issues to litigate about unconscionability. I mean, it still sounds like the actual, there or at least arguments have been made about whether or not we know what the fair market value of the property was back then, and that can be litigated on remand. But if unconscionability drops out, there's still issues about, the fact that the bank has the recorded deed, that RFB did not record its deed. They're then making arguments about inquiry notice. I mean, all of that remains to be litigated. This is by no means over, but I'm trying to figure out how unconscionability really factors into this. If we say, no, you look at the circumstances at the time, Judge Pan has already determined that at the time, everyone thought this property was subject to a mortgage. If you add $53,000 plus $500,000, there's just no way you get to unconscionability, even setting aside Judge Glickman's questions about, don't we need something more than, purchase price? Don't we need some sort of indication of fraud or, unclean hands or bad faith dealing? I'm just trying to see, does unconscionability really survive?
I think it does. And the reason why is this, and I understand Judge Pan's perspective, from sitting on the bench saying this is what we as judges thought the law was. But the buyers in this context, and I think RFB acknowledges this at least tacitly in its arguments, these buyers this was a strategy that they knew there was the potential that this issue, that ultimately the issues that were decided in Liu and 47 Con could go their way. And
right,
so,
but I guess
sorry
to interrupt. You were making the argument in your brief, I understood, that we shouldn't be looking at this from a subjective standpoint. And I was inclined to agree. And I thought, what's subjective about the fact that, sorry, I just have low battery. What's subjective about the fact that a property is subject to a mortgage? That is just something that is true or not. So I guess, now it sounds like you want us to consider subjective considerations.
Well, if the ruling is that if the court's determination on this is you can't look at what happened after the fact, that you then have to look at what it was at the time, then I think we're in the uncertainty area here under the restatement. And in that analysis, I think you have to look at what was the reality that was facing the buyers or the bidders at this sale, in terms of what right. And it's their state of mind certainly pertinent to it, but I think at that point, objectively, you'd want to know, is that, objectively, right? Would a reasonable potential buyer factor in what is the law going to look like on this issue? And I don't know right now, and I don't want to misrepresent it. I don't know specifically off the top of my head where the procedural histories were in Liu and 47 Con at the time, but those cases may have already been well in litigation. I mean, I would, at a minimum, like an opportunity to take a look at that and find out, sort of what did RFB know about those cases and those arguments, because at the end of the day, their strategy here, and I understand it, it was a risk-taking strategy. They saw an opportunity to bid at a price to get a property that's worth a lot more than what they paid for it, recognizing there was some risk. And one of the reasons why they didn't record their deed here was they didn't want to get stuck having to pay all kinds of transfer taxes and other things for a property that they weren't sure if they were going to own it at the end of the day. So,
well, have they admitted to that, or is that your interpretation of
well,
that?
we haven't had a chance. I mean, we didn't, we haven't asked that specific question, but that was sort of how the argument was posited. So I'm not trying to gild the lily too much. I'll be clear. That's my suspicion is what happened here. I mean, this is a sophisticated buyer. I don't think he would have not recorded his deed other than he had a business reason for doing it, because he knew he was putting himself at risk.
We have two sophisticated parties before us. Yes.
And I agree with that. I'm certainly not trying to suggest that we're not. I'm just saying I don't think it was an accident.
If I may, let me just make sure I understand. From a procedural point of view, we have here an appeal from a grant of summary judgment. And if we think there was an error in the way in which that summary judgment was arrived at, because it was based on a misapprehension of the precise way of determining unconscionability, then it would seem as if all we need to do is identify that error, say it was consequential, and reverse the grant of summary judgment or remand for further proceedings. That's the way it looks to me. If that's the road, if that's the legal road we decide is correct. Am I wrong about that? And then whatever happens on remand, go to it.
I mean, in terms of, and I just want to make sure I understand you correctly. You're saying on remand and leave it to Judge Pan to decide whether or not she's going to address unconscionability any further. You would just say, well, the ruling that you looked at it after the fact is set aside.
You're free to do whatever is permitted by the law thereafter in these proceedings. That's the way I'm sort of thinking of it.
Yeah, I mean, look, I think the court could go that way, or the court could remand with instructions to say this is what.
This is only what that means is that this was only an intermediate ruling that's been reversed, and the litigation goes on. I mean, that's the way it's looking to me. If we decide that there was an error on consequence on the material error on the legal approach to unconscionability.
Yeah, and I think if the ruling is that the court's approach to unconscionability on summary judgment was incorrect because it was looking at the wrong time, I still think the court needs to consider whether it should address unconscionability in the context of what we've been talking about here in terms of at the time. But maybe that's an issue that the parties have to present to the trial court and let her decide if she's going to hear that.
Well, we're in no position to say whether, as a factual matter, the price was or was not shockingly low or things of that nature.
Understood, yes. Unless the panel has other questions, I don't have anything else. I appreciate it. I know I've taken a lot of time, but I appreciate the opportunity to be heard thoroughly. Thank you.
Sure, thank you. And Ms. Marquardt, you've reserved a few minutes for rebuttal. We'll give it to you.
Thank you, Your Honor. I just want to address very briefly, I'm not sure I'll even use the whole 3 minutes. There was nothing on the record to support what counsel has suggested, that the reason my client didn't record the deed was because it didn't want to pay transfer or recordation taxes on a property that it might not own. That's just simply not there, and I wanted to make that clarification. In addition, I know that counsel has repeatedly referred again to the 20% guideline, and I just wanted to point out again that I think that's the incorrect guideline here, that there was a number of factors that would have affected a bidder at the purchase price, a bidder at this condominium lien sale. And so the reliance on the restatement's 20% guideline is erroneous and has been rejected by this court. And so
Okay,
I have
counsel,
not,
thank you both.
thank you.
And the case is submitted, and you may both log off.
Thank you very much.
Thank you very much.
Adjourn.